Well, everybody, I think we'll get started. I'd like to welcome you all to our Duty to Consult Origins, Evolution, and Rules of Engagement event. This is our third event for the Centre this year. And I'd like to thank some of you for making a suggestion that we host this event, because some of you said, how could something as simple as duty to consult be a constitutional principle that can somehow stop large, massive resource development projects? Like, what is the duty to consult? How can this possibly be constitutional? And also, how much is not enough? Like, what is not enough? What does that mean? So anyway, we're very, very lucky tonight to have two experts in this area to teach us about the concept and to explain some of those questions and others. So I'd like to begin by acknowledging that we are on Treaty 6 territory, which is a traditional land of several First Nations, Métis, and Inuit people, some of whom signed a treaty in 1876. And as a result of that agreement, we share the land and, of course, are still subject to the agreement in terms of obligations, expectations, and use of the land. My name is Pat Parody, and I'm the Executive Director of the Centre for Constitutional Studies. The Centre is a research centre in the Faculty of Law. Here we do multidisciplinary research on constitutional issues as well as public education. And we take every opportunity we can, actually, to educate people about the Constitution and specifically how the Constitution and constitutional issues impact you in your everyday lives. And of course, tonight's event, on the duty to consult, is one of those. Its impact, the concept of duty to consult, is impacting all of us across Canada. And of course, we know there's been a whole lot of press and government action, government inaction, public discourse on the subject. So we hope that you will feel that you've learned something at the end of it. Now, Kirk Lambrecht, our first speaker, will provide a primer on the duty to consult, how it has evolved into a constitutional principle in Canada, and he will also touch on some of the Trans Mountain pipeline issues. And Sara Mainville will provide a perspective on the duty to consult and accommodate framework in the context of Section 35 of the Constitution. She'll guide the audience through both helpful and problematic rules of engagement. Now, before we begin, of course, I'd like to remind you to please shut off your cell phones or turn them on to mute. You'll note that we are videotaping the event. There'll also be some photographs taken, so if you don't want a photograph or don't want to be recorded in the video, please move to the back of the room. We have evaluation forms in front of you. We really appreciate your input and feedback, so if you would fill those out for us, we'd very much appreciate it. And if you just don't happen to be on our mailing list, there will be a clipboard coming around with that you can sign up for. But if you are receiving our notifications, don't feel you have to sign up. It's just for those of you who want to get notifications and aren't at this point. So our speakers are going to present for 20 minutes approximately each, and then we'll open the floor up to questions. And we have two mics, one there and one over there. And we encourage you to ask questions. Remember, I always give this little speech about the difference between questions and speeches. We hope you'll ask short, pithy questions that our speakers can answer. Okay, and now I have the privilege, actually, of introducing our speakers. So Kirk is going to begin. Kirk Lambrecht, QC, received his law degree from the University of Alberta. He is a lawyer with Shores Jardine in Edmonton, where he has practiced since 2013. And prior to that, he worked with Justice Canada for 30 years, first as a prosecutor, then as general counsel and director of the Civil Litigation and Advisory Section. He was admitted to the Law Society of Alberta in 1984 and to the Law Society of Nunavut in 2014. His main areas of practice are in resource development and labor relations. Therefore, his focus is administrative and constitutional law. He has appeared before numerous tribunals, all levels of court in Alberta, the federal court, and has made several appearances before the Supreme Court of Canada. Kirk has published numerous articles and several books, notably Aboriginal Consultation, Environmental Assessment, and Regulatory Review in Canada, which proposed an integrated natural resource planning model for natural resource extraction that allows Indigenous people, industry, governments, tribunals, and courts to make useful contributions to reconciliation in the context of sustainable development and environmental protection. Sara is a partner, Sara Mainville is a partner at OKT LLP in Toronto. She has traveled a long way to come and speak to us this evening. She brings a diversity of experience as a lawyer for First Nations governments and as a political advisor to Indigenous political organizations and leadership. She actually received her first degree in Lethbridge, she just informed me, so she has a connection to the province of Alberta. She received her law degree at Queen's and a master's degree in law from the University of Toronto. Her thesis is an Anishinaabe perspective of Treaty Number 3, and it was the beginning of a lifetime of study on Treaty 3 and the important place of Indigenous jurisdictions in reconciling Indigenous sovereignty in Canada. In 2014, Sara was elected chief of the, I hope this is right, Couchiching First Nation, and she is active as a political leader in the Grand Council Treaty Number 3 and Chiefs of Ontario committees. She participated in the negotiations that led to the creation of the First Nation Sovereign Wealth LP, which is a partnership of 129 First Nations in Ontario, and in negotiations that resulted in the first commercial transaction between the province of Ontario and this First Nation Sovereign Wealth LP of 14 million Hydro One shares and $29 million in seed capital to facilitate long-term wealth creation for the partnering First Nations. So as you can see, we're very fortunate to have these two experts with us this morning, or this afternoon rather. And so without further ado, I will turn the mic over to Kirk.
Well, thank you, Pat. Thank you, Sara. I was told that I have to go first because I'm supposed to cover some of the foundational stuff. And if all the technology is working, you should see above my head somewhere the subject matter of my talk this afternoon, which is the origins and the constitutional nature of the duty to consult. I have a lot of slides I'm going to go through, and I'm going to go through them at speed. But I will speak in plain English. And firstly, I want to say this is constitutional law, and constitutional law flows from sometimes written constitutions and sometimes from unwritten principles that are recognized by the courts and described as common law. And I think you're going to find in the case of the duty to consult that the duty to consult flows from common law primarily, but is also anchored in a statute, Section 35 of the Constitution Act. So since it comes from the courts, I've taken definitions of things from cases, always from the Supreme Court of Canada, and the duty to consult is described as an obligation that flows from the honor of the Crown. Now, what is the honor of the Crown? The honor of the Crown is described by the Supreme Court of Canada as an obligation that flows from the Crown's assertion of sovereignty and effectively de facto control of land and resources that were formerly in the control of the Aboriginal peoples. And it goes back to the Royal Proclamation of 1763. I'm going to come to that in a minute. But the whole purpose of the duty to consult and Aboriginal consultation is reconciliation of existing Aboriginal societies with the assertion of Crown sovereignty. Now, this is a goal. This is a principle, and I'm going to come back to this at the end when I talk about the difference between universalism and formalism. But this is the reason that it is not possible to know when consultation is enough in any given case, because it is not a mechanical thing. It is intended to achieve reconciliation, and that varies in the context of every case. So the origins of the duty rest in the relationship between the Crown and the Aboriginal people, flowing back to the Royal Proclamation of 1763. So we have to go back into history. And if you know Canadian history, this is the end of the 7 Years' War in Europe, which extended into North America, and was the time when Britain conquered New France. And all of North America, except perhaps the Louisiana part and Florida, but vast parts of what is now the United States, were British. So there it is, the Royal Proclamation of 1763. And here's a little bit about what it says. It says that the king wants the Indians, it talks about Indians here, not Métis and not Inuit, who live under our protection, that they should not be disturbed in their enjoyment of the lands until those lands have been ceded or purchased to us. And this is the root of treaty making in our country. And I have a number of slides to go over the history of the assertion of Crown sovereignty. The first one here is 1763, and all that deep red is British. And there's a quaint little area there called Indian Country, which is, and then Rupert's Land, owned by the Hudson's Bay Company in those days. So as Canada grew, the assertion of Crown sovereignty expanded. And it expanded over time into what we now know as Canada as self. Now, lest you think that this was this assertion of Crown sovereignty was a pleasant time, all Indians and Aboriginal people living under the protection of the Crown, let me go through a couple of points that I must cover here. The Aboriginal people of Newfoundland were killed because of a conflict with the fur trade. Of course, throughout Canada and crossing all Aboriginal societies were the residential schools problem, which I think you must know about as a result of long-standing proceedings of the Truth and Reconciliation Commission. Out west, there's the extinction of the buffalo. And I would invite any of you who have not yet been there to go to Head Smashed In Buffalo Jump, a world-class visitor center in southern Alberta, where you can learn about the importance of the buffalo to the Indian peoples of the prairies. And the extinction of the buffalo was a tremendous blow to that culture. And then for all Aboriginal peoples, of course, smallpox. But I've chosen a slide here to illustrate how profoundly significant this was in the West Coast. The West Coast was heavily populated with Aboriginal people. And in the 1800s, as sovereignty was asserted, there was terrible smallpox epidemics there and a dramatic decline in population. So if you're wondering why reconciliation is the purpose of the duty to consult on the honor of the Crown, these are some of the foundational things that you should not forget. Now, as the Crown asserted sovereignty in this country, it did conclude some historical treaties. The areas in yellow there are those parts of Canada where there were no historical Indian treaties concluded. I'm going to come back to the numbered treaties, which is that large purple area. But you'll see that large parts of Quebec, the North, and British Columbia never had historical Indian treaties signed during the assertion of sovereignty. So the notion that the Indians should not be disturbed until the lands were ceded or purchased was really not honored. So In 1973, there was a foundational case in the Supreme Court of Canada called Calder. The issue in Calder was whether or not the assertion of Crown sovereignty extinguished all the Aboriginal rights. And the court split 3-3-1. And I've excerpted here a passage of the judgment of the court that said no, that there are Aboriginal rights that continue to survive because the Aboriginal peoples were never conquered. So that left the law in a state of uncertainty. The government of Canada at the time, I believe it was the Trudeau government, introduced a comprehensive land claims process under which modern treaty making began. And so large parts of that map that were yellow are now covered by modern treaties. The James Bay Treaty in Quebec was the first of these. Much of the Northwest Territories is covered by treaties, although not all of it. But the Northwest Territories itself was divided into two because of a modern treaty with the Inuit that created Nunavut and some other areas referred to as Nunavik. And British Columbia is a unique place because while treaties are being negotiated, they are not yet finally negotiated. And this becomes an important thing for the pipelines that cross those areas where there are land claims that are being negotiated, but they're not finally negotiated. So in 1982, our government in this country saw fit to create the Constitution Act 1982. It has the Part 1, which is the Charter of Rights and Freedoms. And in Part 1 is this part that says that none of the rights and freedoms recognized in the Charter of Freedoms abrogate or derogate from Aboriginal or treaty rights enjoyed by Aboriginal peoples recognized in the Royal Proclamation of 1763, or any rights that may exist or be acquired by land claim agreement in future. And then, of course, Part 2 of the Constitution Act, this is not the Charter, it's Part 2, has Section 35, and this recognizes the existing Aboriginal and treaty rights of the Aboriginal peoples of Canada. And Aboriginal peoples are described as Indian, Inuit, and Métis peoples. And of course, in that act is Section 52, which is that this is, the Constitution is the supreme law of Canada, and any law or act that is inconsistent with that is of no force and effect. And this is why pipelines are shut down, because the duty to consult has a constitutional power by virtue of this provision. Now, I'm going to jump then to the duty to consult specifically against that kind of historical background. The duty to consult was recognized by the Supreme Court of Canada in a case called Haida in 2004. And I say recognized because I think they would say it always existed, but now they're going to create it. So here you see the highest court in the land creating constitutional common law. And it's grounded in the honor of the Crown. And it's part of the process of fair dealing and reconciliation that begins with the assertion of sovereignty and continues beyond formal claims resolution. So this is going to be with us for a long, long time. It is not something that has an end point. It is a process, a constitutionally imbued process. And this is when it arises. It arises when the Crown has knowledge, real or constructive, of the potential existence of the Aboriginal right or title and contemplates conduct that might adversely affect it. So if the Crown is thinking of doing something that might adversely affect Indian, Métis, or Inuit actual or asserted rights, then they must consult and, where appropriate, accommodate. That's the obligation. But it has a generative constitutional capacity, and this, I think, is profoundly important and something that people struggle with. So it serves a dynamic and not a static function. That means that when a case arises, where the honor of the Crown requires the Crown to act in a certain way, then the generative capacity of the honor of the Crown and the duty to consult will create a remedy where none existed before. Now, I'm at the end of my career, but you and yours are going to see these remedies arise. You will see it in the pipeline cases, but I think you will see it in other cases that we just can't imagine yet, because the honor of the Crown has not yet been fully applied to all the circumstances that may arise, and we have not achieved reconciliation. Now, it's fundamentally important to understand that Section 31 restrains that the rights that are recognized in Section 35(1), and the honor of the Crown in particular, restrains legislative power. This is profoundly important. That means that the powers of the federal government and the powers of the provincial government that are allocated to them in the division of powers in the Constitution Act 1867 are subject to the satisfaction of the duty to consult and the honor of the Crown. And here you see the Supreme Court of Canada referring to the honor of the Crown as a constitutional principle. The generative capacity is something that flows from concept of a learned author called Brian Slattery that the court, I think, was influenced from. The honor of the Crown has 4 applications so far. It's not a cause of action in itself, but it talks to how obligations must be fulfilled. So you don't necessarily need what's called a cause of action to bring an action for breach of the honor of the Crown. A fiduciary duty can exist, and that will occur when the Crown controls Indian lands. And that has arisen. And so in that case, the honor of the Crown applies to the fiduciary duty to reinforce the fiduciary duty that the Crown would otherwise be under. It informs the purposive interpretation of Section 35 and gives rise to the duty to consult. The honor of the Crown governs treaty making and implementation, and there's not to be any sharp practice in treaty making or implementation. And it requires the Crown to act in a way that accomplishes the purposes of the treaty and the grants to Aboriginal peoples. And that's just where it's been recognized so far. As I said, the honor of the Crown has a generative capacity, and it will be recognized by the courts in other contexts. Now, I want to talk a little bit here about the historical Indian treaties. And I'm particularly talking about what are called the numbered treaties. They appear in purple on that map. Sara, I think you're Treaty 3. Here in Alberta, we have Treaty 8, Treaty 6, and Treaty 7 running from north to south. And Treaty 8 covers all the oil sands areas. So the Supreme Court of Canada, in a case called Mikisew Cree, says the Treaty 8 gives the Mikisew procedural rights, consultation, as well as substantive hunting, fishing, and trapping rights. So in the case of the numbered treaties, all that purple area on the map, consultation is a treaty right. And the treaty rights are recognized and affirmed by Section 35 and are paramount by Section 52 of the Constitution Act 1982. So this is a tremendously powerful tool. And in a case called Keewatin versus Ontario, the Supreme Court confirmed that the exercise of powers by the federal and provincial government are subject to the rights guaranteed by the treaty. So the exercise of provincial power by the federal and provincial governments are subject to the treaty rights in the numbered treaties, and this means subject to the duty to consult and accommodate. So after Manitoba Métis, Brian Slattery wrote a little summary describing the duty to consult as constitutional common law, and that's what I think that it is. And it applies to the executive branch of government, not the legislative branch of government, not the judicial branch of government. Now, this isn't a place for a detailed discussion about what the executive branch is, but I have put this chart in my demonstration to give you a visual of what the executive branch is. So when the executive branch makes a decision or contemplates making a decision that might adversely affect actual or asserted treaty or Aboriginal rights, then it must then consult and accommodate the Aboriginal peoples who may be affected by that decision. And why is it so difficult to determine when consultation is adequate? Why can't we know when we've consulted enough about interprovincial pipelines? The answer lies in the fact that, discussed beginning in the Supreme Court of Canada case, the contexts of Aboriginal peoples across the country are so different, and the contexts of Crown decisions that might affect those rights are so different, that you must take a case-by-case approach to whether the duty to consult applies. And if you read an article written by Madam Justice McLaughlin on former Justice Ledane, she talks about the difference between formalism and universalism in law. Formalism is rules and procedures, and universalism is principles. Most law students are taught rules. If this happens, then that is the result, and the law of stare decisis says that should always be the result. So if you have a case like this, then that should always happen. And that works great for contracts, and it works great for car accidents, but it does not work for Aboriginal consultation, because Aboriginal consultation is based on universalism, and the goal of the Honour of the Crown is reconciliation. And you will not know if reconciliation is achieved by doing A, B, and C. You must know in the context of the specific case. So you should not look for formalism to satisfy a constitutional obligation based on universalism. The controlling question in every context is what's necessary to achieve reconciliation, and the Supreme Court tells us that that varies with the context. They use a spectrum. If the chance of impact of Crown conduct is likely small or less significant, then there's not so much that the Crown has to do to consult and accommodate. But if it is significant, then there's a lot more that the Crown has to do to consult and accommodate. And the Supreme Court does say that in some cases of established Aboriginal rights, that Aboriginal consent may be required. That part of the law is not well developed yet, but it exists, in my opinion. As I said, reconciliation is always the goal, and there's no such thing as untrammeled public discretion to force a decision through, because the constitutional obligations are paramount. And I've hit my 20 minutes. And that is the end of this part. I was asked to speak a little bit about pipelines, so if you don't mind, I'm going to take just a few minutes here to talk about why in the world this constitutional duty to consult stopped the Kinder Morgan and Enbridge Northern Gateway pipelines. I'm only going to take a few minutes to do this. I have to, therefore, oversimplify, and I apologize because I'm not able, in the time that I have available, to give a full explanation of the context for these matters, but I am going to pick on the one thing I think that I see as key. I'm going to talk about the Honour of the Crown and Cabinet decision-making in the environmental assessment and regulatory review process applied to the Enbridge Northern Gateway pipeline and the Kinder Morgan Trans Mountain pipeline, both of which were the approvals, both of which were overturned by the Federal Court of Appeal because of a failure of the Federal Crown to do adequate consultation and accommodation at a particular point in the regulatory and review process of those things. And so in case you're not familiar with Enbridge was a really big project. It was that little red line would have been a two-way pipeline. It would have taken bitumen to Kitimat, where it would have been put on the Supermax tankers and taken overseas. So it would have given us access to tidewater for that product. And dilbit would have come back. Dilbit is a diluent that is used to help a bitumen flow through pipes. Key to understanding what went wrong here is the Harper government's change to the National Energy Board Act, and to make the governor in council responsible for final approval of the project, and to give reasons. And so here's a generic process map. If you start in the upper left-hand corner under planning there, the oil company decides it wants to build a pipeline. You go down to the bottom. It goes through an environmental and regulatory review process overseen by the National Energy Board because these are interprovincial pipelines. It then goes over to the right. The cabinet approves it. With cabinet approval, the oil company then has its approval. It makes a final decision whether it's going to build that pipeline. If it does, it builds the pipeline, and the National Energy Board oversees the pipeline through the course of its lifetime. Now, most Crown consultation and accommodation that occurs in relation to projects, mines, gas wells, occurs in the lower left-hand box, which is where the tribunal, the National Energy Board in the case of pipelines, is conducting a review. So consultation is done by the project proponent, and the Crown relies on the tribunal process to discharge the duty to consult. And the tribunal has some power to be responsive to Aboriginal concerns by imposing terms and conditions on approval. But in the case of both of these pipelines, there was another stage in the consultation process after the conclusion of the National Energy Board report and before the Governor and Council report. That was in the case of Enbridge called Phase 4 consultation. And the Federal Court of Appeal found the Phase 4 consultation by the Crown to be inadequate, brief, hurried, inadequate, and no meaningful opportunity to respond to the Aboriginal concerns that were raised. That, in my view, was the fatal flaw. Why did it exist? Because if you look inside government, you will see tremendous forces at play that resist imposing constitutional obligations on the Governor and Council and on Cabinet. There's a tremendous resistance there. And they thought, oh, it's all, in most cases, it's just done by, the government does nothing. Nothing. And they just rely on the National Energy Board process. But because this was deep consultation, they had to do more. And they did consultation after the NEB process and before the Governor and Council decision to say, hey, despite all the consultation that has occurred, we know you still have concerns. What more can we do to accommodate those? And that's all they did. Thanks very much. We'll write that down. Project approved. Federal Court of Appeal said that was not consistent with the honor of the Crown in the Enbridge Northern Gateway project. And it is ironic beyond words that it is the Harper government that was responsible for the failure of that project by the failure to embrace the constitutional obligations that rested upon that government to fulfill Aboriginal consultation, to make sure that that project was built. Go back to that stage. Brief, hurried, and inadequate is what the Federal Court of Appeal said about it, about a project that was, in the view of the Harper government, absolutely in the national interest. So let's go to Kinder Morgan. Kinder Morgan is an existing pipeline already. It is our only tidal pipeline. So otherwise, all the oil and gas that is all the oil that is produced in this country goes to the United States. And the United States, of course, now is self-sufficient in oil, which is why ours is trading at such a dramatic discount in these weeks. This would have increased the size of the Kinder Morgan pipeline significantly. So there was another project agreement. Again, this was done by the Harper government because the roots of this are in the time of the Harper government. Under that project agreement, they had consultation after the National Energy Board report and before the Cabinet approved the project. In this case, it's called Phase 3 consultation. It was Phase 4 consultation in Enbridge Northern Gateway. But it was only supposed to last 3 months. So before the general election even occurred, the Harper government decided unilaterally that this would take 3 months to do consultation with all the Aboriginal groups after the National Energy Board report and before the Governor and Council decision. You should see in that a refusal to recognize the constitutional obligations resting on the Crown. Now, the government changed, but shockingly, no change occurred in the federal government approach to Aboriginal consultation at that stage. And in striking down that pipeline, the Federal Court of Appeal said the consultation team acted on the basis that for the most part, they were there to take notes, to report the concerns of the Indigenous people to whom we don't know, because everything that occurred after that is subject to Cabinet confidence, which the Crown would not waive. So there was no responsive capacity for the federal officials that were obligated to do consultation. They didn't have the ability to say, yes, we understand you have that concern, and can we address that concern in this way? So it's the same process in both pipelines, and it's the same problem. And I think that it's not a problem in the environmental assessment and regulatory review process. It is a problem in the willingness of the highest levels of government to embrace constitutional obligations. So in Alberta, if you have a project like a bitumen mine that has profound impacts on Aboriginal people, the government consultation in this province will end with the Alberta Energy Regulator decision. And there will be no consultation between that and the approval of the project by the Lieutenant Governor and Council. So I think the problem that we saw in the pipelines is big. And it means, and I think that we're seeing signs of recognition of the problem in what the government is saying that they intend to do now to get Kinder Morgan built. But the essential problem is a failure to embrace the constitutional obligations at the Cabinet and Governor and Council level. And the legal risk will remain high in cases of deep consultation until that matter is fixed. So thank you very much. It's been a privilege to speak to you, and I'd like to turn the podium over to my colleague Sara. She has matters to speak to you about that I hope will overlap with these.
Good evening. It's a pleasure to be at this university. I'm doing a bit of a university tour. I was at University of Saskatchewan a few weeks back talking about Trans Mountain. And it's really interesting to be out west. I did do my undergrad out west, and definitely a different climate and a different perception about the emergent need for there to be a pipeline approval sometime in our near future. And certainly living in the center of the universe, otherwise known as Toronto, there's definitely a different perspective on that. I want to introduce myself traditionally, being in Treaty 6 lands, Buju, Kabamashit, Pinisikwe, Indigenous Cosmoquat, Dodem, Kuchiching, Nindoji. I am a Treaty 3 person. I very much take the work that I do very much from a treaty perspective, and thinking about how treaties, a lifelong project of mine is to think about how implementation of treaties is really our collective national project. So I'm going to talk today about treaty relationships, and treaty relationships being the key to reconciliation. Nations allowed to coexist with their own laws, institutions, and communities. And secondly, consultation. Consultation being a government-to-government process, a government-to-government relationship, and co-designing processes within both jurisdictions. And also the promise of treaty being wealth sharing, being our mutual prosperity. I'm going to talk about treaties and think mostly about whether or not we're actually really reconciling at the government-to-government level, meeting as governments, meeting as societies, deciding what kind of development should happen in a particular region that's shared, or if we're actually reconciling rights and balancing the public interest based on impacts to those rights. And I think that's been the problem when First Nations see consultation frameworks, is they see it very shallow and very narrow, focusing on basically looking at hunting and fishing and harvesting rights and whether or not those could actually forestall any future development. And for the most part, we've seen that as a losing game. So this idea of this framework being a competition with winners and losers has always been the problem of consultation regimes, I think in every province, and certainly for those of us who are part of numbered treaties. It's definitely not where we want to be. Winners and losers is not a relationship of coexistence. That adversarial relationship, it has to stop, because treaties are about peace. Treaties are about mutual benefit. So going into the numbered treaties and the historical treaties, you see this case called Siwi. It came out around the same time as the Sparrow decision came out. Sparrow, of course, is the first Section 35 decision. I'll come to that. But Siwi talked about the importance of the treaty relationship to the founding of Canada. That unlike the modern treaty areas, the numbered treaty areas were places where there had to be a relationship with Indigenous peoples. For example, I'm a Treaty 3 person because my ancestors didn't originally want to make a treaty. We're actually the most eastern numbered treaty, but we're not Treaty 1, because actually we sent scouts to Montreal to see if we actually could win a war with the British. Because they were breaking a treaty that they made to send a canoe route called the Dawson route from Thunder Bay to Winnipeg, otherwise known as Fort William to Fort Garry. And so we didn't sign a treaty right away. It took 4 years to make Treaty 3. So Treaty 1 and Treaty 2 came before Treaty 3. And so to understand that important history, it astounds me when I meet with the Attorney General, and I have met with a few Attorney Generals, including Minister Wilson-Raybould, and I need them, for me to really believe that Section 35 is going to work, I need them to understand the history of our treaties. I need them to, because that's the only way that we can truly reconcile them. So we've had a bunch of studies, of course, after Oka. I don't know if any of you remember Oka, but certainly you can look it up on YouTube, the Oka conflict. After that, I think it was the Prime Minister Mulroney who ensured that there was a Royal Commission on Aboriginal Peoples. It included former Chief Justice Brian Dixon and others. And the Royal Commission on Aboriginal Peoples went across the country. Actually went to my community. I was I think, in high school when they came to my community. And they talked to us about different relationships. They heard a lot about residential schools back then, but they also heard about treaties. And they heard from most treaty people that they didn't know what this idea of surrender came from. Where did this come from? Because our oral tradition didn't talk about a surrender. And certainly, if you look at the Keewatin case, the Grassy Narrows case that went to the Supreme Court of Canada, the trial decision actually talks about the fact that the Treaty Commissioner actually didn't bring that part of the Articles of Treaty, the written document, didn't bring that up in any of the 4 days of the discussion. They actually didn't bring it to the Anishinaabe people and said, you know, this is also part and parcel of the agreement. You are going to surrender all your lands. In fact, the actual oral guarantee, the agreement between the treaty commissioners and the Anishinaabe were that they could continue their harvesting rights throughout their territory. They could continue that. That kind of evidence actually happens in Treaty 9. Treaty 9 is in Northern Ontario, where actually this person called Duncan Campbell Scott, I don't know if you recognize that name, certainly comes up in the residential schools. Duncan Campbell Scott actually instructed the treaty commissioners not to bring up the surrender. But it was a racist argument that the Cree and the OG Cree actually wouldn't understand it. It would be too confusing, so just don't mention it. And this is why the Royal Commission says, if you don't have evidence, if you don't have clear evidence that there was consent to these surrenders, don't rely on them. That's how we can get to reconciliation. Don't rely on the sharp dealing that happened around these articles of treaty. And for the First Nations, don't say that you don't have a treaty. You have a treaty. There was some kind of arrangement made about sharing of lands. You know, don't say that you're the sole landowner in these territories. You know, in Delgamuukw, they say, we are all here to stay. You know, don't pretend that you're the landlord and you can just say, okay, that's it. You're not paying your rent, you must leave. That's not what treaties were about. They were about peace. And that's always in my head, it's about peace. Section 35 was about recognizing and affirming rights. And certainly that has not happened. Section 35 is said in this excerpt from Sparrow, a Supreme Court of Canada judgment. It affords Aboriginal people the constitutional protection against provincial legislative power. This is key. This has been not really an idea that's been enforceable across the Supreme Court judgments after that. In fact, to my dismay, I see more and more litigation happening where Sparrow's not even in the pleadings, well, not even in the factum. We rely on more current case law. But this idea that the provinces would be too self-interested to actually deal honorably with treaties is old colonial case law. It actually exists in the United States in a case called Kagama. The Supreme Court in the United States understood this full well, that the Congress has to be the power, the authority to implement treaties because you can't rely on the states because the states are too self-interested to take Indigenous land. And the same with the provinces, and we forgot that. So I'm going to go through some of the case law. I'm not going to read it, but certainly the items in red are things I want to highlight. So when we talk about the consultation frameworks, the courts have been trying to carefully instruct governments, crown governments, that this is not you simply adopting the decision-making in the statute. If it's an impact assessment law under C69, or if it's environmental assessment law in the provinces, it's not simply about you making the decision about whether or not environmental assessment the study in the mitigation measures should be approved. You actually have to think about and consider the impact to Section 35 rights. And you have to do it in a way, practically, and I like that the first speaker talked about this idea about it's not a formula. It's the principles that get you to the end result of having some kind of an arrangement that accommodates Section 35 rights. And it's certainly up to the First Nation on what they're going to agree to. And I know there's controversy across Canada about some of the First Nations that are actively engaged in impact benefit agreements. But that's all about self-determination. That's all about understanding that people self-determine and make the decision. They consent freely to whatever deal they want. They can make mistakes. Or they can do, what is practically the best result for that community. That's important. The idea with consultation is that we're developing, especially in the better arrangements, is partners in development. I work for clients who, after long engagements of 6 or 7 years with different proponents, actually talk about the project as theirs, something that they want to happen, because there has been a real rich relationship that has been developed between the proponent, and sometimes the Crown gets involved in generally, if there's a good representative of the Crown who knows the First Nations, there'll be a good relationship there as well. But the whole idea is that you're trying to get to a final arrangement that the parties can all live with. But the reconciliation is finding a space and a place in the future for First Nations in the development of their territories. So we know this consultation is in a spectrum. There's a weak claim, no serious impacts. You have less consultation requirements, and I'm going to have a final slide on what this actually looks like. And a strong claim and serious impacts, we have more consultation. We actually might get to the point where you need to have consent of the First Nation. So this is the basics of the duty to consult and accommodate framework. What we're experiencing is an expectation gap. So there's an expectation gap between the governments who basically thought that they had a formula. They looked at the spectrum and they said, okay, let's calibrate this all. Is it just notification? Should we go through the process, go through the fuller process? But actually not really willingly participating in the process, that the end result would be that the First Nation would be comfortable with the project, would participate in the project, or depending on the impacts to the First Nation. And so we find ourselves in court or tribunals or some type of dispute resolution more and more often, because it's that process where you actually get the government decision maker to wake up and say, oh, right, we didn't consider those things. We didn't really consider these impacts, and then having to come back to some form of reconsideration through court process. That's highly inefficient and problematic. There's so much more that could be done, and especially the law students in the room, there's an expert panel report that was provided to the Government of Canada, and there's a recipe in there that actually gets to free, prior, and informed consent that should be considered by different governments is a framework that is actually practical and workable. And basically what it is understanding that there's a negotiation process. There's agreement to be defined for the process, a co-design process with the First Nation parties. So you'll hear this again and again. Consultation is about the relationship. This is the case of Mikisew Cree, the Treaty 8 case that went to the Supreme Court of Canada. But consultation goes back to treaty relationships. I'll give you an example with Treaty 3. In Treaty 3, this was agreed to on October 3rd, 1873, and the agreement was being read back to the Anishinaabe. My chief, who was one of the lead spokesperson, Mawandapanis, said, okay, now that we have this agreement, I will tell you this. I will hunt you down. You personally, and he was pointing at the treaty commissioners, I will hunt you down if this treaty is breached. And the treaty commissioner, who happened to be the lieutenant governor of Manitoba and the Northwest Territory, said, no. You don't have to do that. You don't have to go to those lengths. I promise you the Queen's government ear. You will have the Queen's government ear anytime you have grievances. What does that mean today? What is the modern evolution of that? And that's the relationship. Prior to Treaty 3, one of the chiefs had said, we need to know where you want to build your roads. Once you have the design or the plan for all the roads that you want to build in our territory, then I think we could come to a treaty. Because I know that you're saying that you justly deal with Indigenous peoples, in your own lands, meaning probably Upper Canada. We know that you said that you've dealt with the clemency and justice, but we need to know this before we have a treaty. And that, again, is about consultation. So these are old concepts. And, of course, the Order of the Crown came out of colonial treaty law. So there's another, I don't know how much more time I have, but I just want to hit on free, prior, and informed consent, because this tends to be the elephant in the room now that we're coming up with consultation agreements with governments, is the standard of free, prior, and informed consent in the UN Declaration on the Rights of Indigenous People, in particular Articles 19 and 32. Article 19 is before the adoption of legislation or administrative policies that impact Indigenous peoples. This is not a panel on Mikisew Cree, but I certainly can share some of my thoughts on that recent judgment about the duty to consult in creating legislation. And then there's Article 32, which is basically the scary part of implementing the Declaration in Canadian law. It's about having the standard of free, prior, and informed consent before undertaking projects that will impact Indigenous peoples and their territories. Consent doesn't appear much in case law. You see it in Delgamuukw and Chillicothe here about the Aboriginal title rights. And this is in the passage in written, and if you forgive me, I'm going to read it. It says, after Aboriginal title to land has been established by court, declaration, or agreement, the Crown must seek the consent of the title-holding Aboriginal group to developments on the land. So that's where the Government of Canada, and recently the Government of BC, have said, is their drafting legislation, in particular environmental assessment legislation, is saying, well, we have to codify this in our legislation. So they're basically saying that if you have a modern treaty where the treaty says that you have the right to consent, then we'll have to seek your consent on these developments in those lands. It's certainly not leaps and bounds developing and progressing a relationship. But Bill C-69 and the BC environmental assessment legislation at least says that. Following Chillicothe. So I'm not going to leave this slide, but it's basically it's out there. It's on the internet what free, prior, and informed consent means. But I would just want to tell you that this is not it's not outside of a peaceful relationship. It certainly is a cornerstone of a peaceful relationship. If you've ever had a roommate, if you've ever lived with somebody, asking them if they mind if you do something is just a part of having a mature relationship with somebody. Doing things unilaterally is not the best way to have a relationship. So free, prior, and informed consent is an ingredient of a better relationship. So industry groups have adopted this, and the World Bank, for one, has adopted this, is a standard. And you're seeing it come up in some impact benefit agreements, certainly where the First Nation is almost is right next door to the development. You'll see the FPEC is a standard being processed as an agreement. It's in the procedural rights in the waterfalls related to an IBA. There's also increasing support from federal and provincial governments for the UN Declaration itself, and then we'll see what will happen with the implementation of Bill C-262, which is the implementation of the Declaration Act. That's still in Parliament. So why is consent better? It encourages a more just consultation process. It better reflects this goal of reconciliation, again, reconciliation at the society level, mutual benefits, mutual caring. It creates certainty and some more fairness. And I believe strongly that it's more sustainable. It creates greater social stability, this idea of social license, of course. And it leaves a better history about future developments. Because you find again and again, and you'll see this in the case law, that you'll see a First Nation that they're bringing their grievances, their historic grievances to the court. And they're not just talking about that particular development. They're talking about a century of alienation of their traditional territory, such that they may or may not have any meaningful treaty rights to harvest. So IBAs are really important, impact benefit agreements. That's a lot of the work I do. And this is probably a better slide. Basically what it tries to do is it tries to balance out the impacts of a project to create a more solid foundation for the development to actually benefit in an equalized way the First Nations that are agreeing to these impact benefit agreements. And we've seen some wonderful social progress made by some First Nations who are working actively with proponents to co-develop their traditional territories and their resources. And there's definitely some good news stories out there. So finally, some of the rules. So basically, there's a very low bar for the duty to consult. So the best thing is to give notice to any and all of your hosts. So if you're developing a territory, to know any and all your hosts in that territory, give them notice of what you're doing. Disclose information. Give the First Nation time to respond. And we're seeing that in some of the case law that courts are very sympathetic to many of the issues that First Nation governments have in responding in a timely way to some of these notifications. And certainly some of the First Nations are right in smack dab in the middle of a lot of development, and responding to hundreds of notices is difficult, especially if they have very few staff. Address the concerns that are raised. Consider alternatives within the project planning. This is why it's really important to do this early, to do the work early before you start putting shovels in the ground. And think about participation funding. It's a good investment. Also, there's some really good economists working in this field that will talk to both proponents and to First Nations about how to make the project successful, so that you will not just have windfalls, of certain times in the project, but you actually might share in the profitability of the project for a longer term. The higher end of the process, the spectrum, is that you co-develop a process. I've done work with First Nations where we've co-developed some very unique consultation processes, and actually the end result is a really good relationship with proponents. Also talk about preferences to Indigenous people. Just don't present, for example, the mitigation plan to First Nations. Actually work with them to see what their preferences are for mitigation. And if there are proven rights, certainly talk to the First Nation about consent if you are impacting proven rights. Even if there is no consent, the Crown has a pretty high standard to justify any infringements to treaty rights. So it's really important to engage and engage and engage. And accommodation is certainly where we all want to be. And for the most part, it's the governments that have to accommodate these rights. It's not necessarily the proponent that has to accommodate these rights. So it's important for the Crown to be involved. And that would achieve, in my estimation, the pathway towards free, prior, and informed consent. Thank you.
Okay, so now we're over to you, audience. If you have questions, as I've said earlier, there's a mic over on that end and one over here. And we'll just go from one side to the other. So you'll just take questions from your seats, I take it. Okay, so why don't we begin with...
Is this on? Yep. How does the dance between the different levels of government work? So if say there's a major project, call it a mine or a pipeline, Section 35, I assume, triggers a federal obligations and duties. But what role comes in terms of the province's obligations if there's, say, a joint review panel? And what happens then if, in, say, the development of the impact benefit agreements, I mean, that's primarily the companies, but in some cases, maybe people from the province get involved. And what happens, how do you tell whether that duty's been satisfied? If there are two levels of government involved, and conceivably if their interests differ or oppose. And I could provide a little more detail on that hypothetical if you want.
I'll just say something shortly. I'm just gonna. This is on. So I'm gonna just begin, and then I think Kirk is gonna finish the answer. But a lot of the times there is some type of harmonization in the statutes. So, for example, with environmental assessment, there will be different processes about different things because the federal jurisdiction is different from the provincial jurisdiction. They could be assessing different matters, and this makes no sense. So it's better when there's a harmonization agreement, and hopefully First Nations are involved in the process to do the assessments, so that they're engaged at the early time to do this. But for the most part, the proponent is leading a process, and the proponent is driving the timelines in a lot of these statutes. So I'm going to punt it over to Kirk, and he can give his from the government perspective, because I don't know how this is proposed to. This is proposed to actually be a workable solution, because in those instances it actually causes confusion and probably some inefficiencies.
Well, I think I'll start by emphasizing that context is important. So the context of your question was development of some kind, like a mine. Let's talk about a mine. All right, different considerations might apply in a different context. But in the case of that kind of a project, the basic thought process is that if the developer can do what they can do to achieve reconciliation, and if the tribunal that is charged with the obligation of environmental assessment and or regulatory review can do what they can do to contribute to reconciliation, then the crowns, whether federal or provincial, have to fill in whatever might be left to contribute to reconciliation before any approval of that project is given. Technically, if only one crown is obligated to take action in relation to that project, let's say it is a mine in a national park, then there is no provincial crown involved. There is only the federal crown involved. But if it happens to be, let us say, a bitumen mine on provincial crown land, but emitting chemicals which might have an effect on fish or drawing water out of a river that might have an effect on navigation of that water that are federal matters, then both the federal and the provincial crown would have some obligation to do what they can do to contribute to reconciliation. And so I think that is how I think the model should work. The way the model does work is that the crowns do basically nothing and leave it to the proponent and the tribunal, and then they approve the project in most cases. And that's why you saw the pipelines fail, because the Crown didn't do more than that. It just sent people out to take notes and say, thanks very much, we're approving it. I hope that answers your question.
Thanks. And thanks for coming today and speaking to us. My business background is as a planning development consultant and rural developer. Educationally, my undergraduate degree is in Native Studies, and I'm a master's student here in the Faculty of Native Studies at the U of A. My master's thesis is on the duty to consult. My question relates to Bill C-262. it appears to commit the legislative arm of the Canadian government to implementing UNDRIP into past and future Canadian statutes. It achieved third reading by a large margin in May of this year, 2018. Is it now likely that Bill C-262 will be proclaimed? And most importantly, once proclaimed, will it be effective? Do you feel that it has the chance to be effective at its intended purpose?
He's talking about Andrew. He's talking about Bill C-262. Yeah. So I'm involved in this, right? So some of my clients include Assembly of First Nations. I've worked with the Assembly of First Nations on Bill C-69, the impact assessment legislation, and I'm working with another organization on the federal rights recognition framework, which unfortunately my client's trying to stop it. Actually has a hashtag or a website saying stop the framework. So Bill C-262 started off as a private member's bill by Romeo Saganash, who infamously said that Justin Trudeau does not give a something about Indigenous people. And so the bill has been supported by the Trudeau government because it's a soft way of implementing the UN Declaration. And the soft way is this, that they commit to work jointly with Indigenous peoples to have a national action plan to implement the UN Declaration. Unfortunately, as I've mentioned before, the problem is always when things are done unilaterally. And at the outset, just before supporting Bill C-262, the Trudeau government put out these 10 principles respecting the relationship with Indigenous peoples. The 10 principles are not the Indigenous perspective on Section 35. They're largely likely, and I'm not going to say bad things about I have several friends in the Department of Justice, largely crafted by Department of Justice lawyers about a version of Section 35 that they think is implementable. It's not the Declaration, it's not the articles of the UN Declaration, it's not about free, prior, and informed consent. They water it down a bit, and one of the principles, I think it's 6, says attempt to achieve free, prior, and informed consent. So these unilateral actions make First Nations believe that, there's a lot of good words about implementing treaties once again, but it's likely that it's going to be something quite different from the Indigenous perspective of how implementing treaties should actually happen. And so Bill C-262 is likely going to become law, but how the Trudeau government works with Indigenous peoples, who are they going to work with? They're probably going to work with the national Indigenous organizations, being the Assembly of First Nations, the Métis National Council, and the ITK. And whether or not that's good enough for Indigenous peoples, I would say, especially being here in Treaty 6 territory, I doubt the Indigenous leadership in Treaty 6 believes that that would be enough. So this National Action Plan is going to be probably based on the Sustainable Development Goals of the UN and very soft leading sort of principles about Indigenous rights that gets us no nearer to the actual implementation of a treaty rights framework or the protection of treaty rights in law.
Thank you.
Hi, good evening. My name is Kaisel. So I'm a political science student here at the University of Alberta. First of all, I would like to thank you for coming here tonight to speak to us. So my question has something to do with the recent decision of the Supreme Court of Canada, the Mikisew Cree First Nation v. Canada. And I'm not sure if you touched upon that during your speeches, but my question to you is, in your perspective, I don't know if I should give context. So the Supreme Court of Canada rules that there isn't any duty to consult during the lawmaking or the legislative process. So in your perspective, how big really is this of a blow to First Nations in terms of the positive evolution of the duty to consult in the long run?
Well, I'm not sure I can speak for First Nations. I would say that what occurred in that case was anticipated by the Supreme Court in an earlier case where they said, all right, when they recognized the duty to consult in HIDA, they said, it's our job at this level of Supreme Court of Canada is to create a framework. And we're just going to create a framework, and we're going to say, okay, this is where it applies, and these are the principles within it, and we're going to leave it to the lower courts to work out the details in the time-honored tradition of the common law. In one of those cases, they said, we're going to reserve to a later day if the duty to consult would apply to legislative action. That is the promulgation of bills in a legislature or parliament. The case that you're talking about was that case. Technically speaking, the Supreme Court of Canada judges all held that the federal court had no jurisdiction to consider the case. That is what is described in classical legal analysis as the ratio of the case. The federal court has no jurisdiction. The Supreme Court has a long settled practice of not going further in constitutional cases to make pronouncements that aren't binding, but in this case, it appears that because of the significance of the issues, the judges decided to do that. And so that part of their decision is technically what is described as obiter dicta. But it's pretty persuasive obiter dicta. It's a bit like Calder, you know, because I think it's fair to say that the majority of the judges said that it would not apply. So if the same case were to come back, you would likely get the same result. So it is fairly persuasive result. I don't think that that is a tremendous surprise in the development of the law of the duty to consult, that it should not apply to legislative action. I did not think that was a surprise. What surprised me was that the court decided to split into 4 different parts, and the judges wrote 4 different decisions. So if the intent of the court was to give guidance through obiter dicta about the duty to consult, it does not help to get 4 different judgments that are widely divergent in some respects. So that particular decision, I think, is a bit of a concern because the court split, but it's obiter dicta. So I'm hoping that the court might return to the unified days of the McLaughlin Court should a future case about the duty to consult or accommodate or the honour of the Crown come before it.
Oh, if I may, I'd like to just explain some of the work that I do. So with Bill C-69, the Assembly of First Nations wanted to actually co-develop that legislation, not just the Indigenous parts, but the actual entire legislation. So the perspective of the Indigenous peoples was that there should be a duty to not just consult, but actually share the pen on creating legislation that impacts First Nations. And certainly Article 19 of the UN Declaration is still out there, saying that states shall try to achieve, or shall get the free, prior, and informed consent of Indigenous peoples when they create legislation or policy that impacts them. So that creates expectations when the Trudeau government says that they're going to implement the UN Declaration. There certainly is a co-development process with the Indigenous languages legislation. There's a child welfare legislation for First Nations after the Sidney Blackstock First Nation Caring Society case that my colleague Maggie Wente from OKT is involved in. With the, if we get this federal framework right, there will be co-development of some kind of rights recognition legislation, but certainly it's proposed in Bill C-262 that the Trudeau government will work with Indigenous peoples to co-develop a national action plan. So there's different ideas around how the government of Canada should work with Indigenous peoples participating directly in some elements of governance, but I think it stops at the door of drafting legislation.
The context of that case involved bills in the legislature, but the court used the phrase the lawmaking process in a number of parts of the judgment. I think the court was referring to the process of making bills in a legislature or a parliament. But as if those of you who are here as law students may recognize, the modern state makes laws in a lot of ways beyond bills in the legislature. The legislature may delegate the authority to make laws to the governor and council or to ministers. And those powers can be, in turn, subdelegated. And there is a vast lawmaking apparatus at that level that exists that the court did not address. So the precise boundaries of the framework have not been definitively determined, it seems to me, by that judgment. And there will need to be further cases for there to be more clarity on whether the duty to consult might apply to lawmaking process beyond bills in a parliament or legislature.
We'll take one last question.
I'd also like to thank you both very much for being here and sharing your knowledge. My observation is that the duty to consult sits a bit awkwardly in the rest of the Canadian legal system. Like, it's not something that you can create a nice 3-part test for. And I wondered whether you had any thoughts on whether the duty to consult or the real idea behind it maybe fits better within Indigenous understandings of law as performance-based obligation, or as something that sort of inheres in the enactment of a relationship, and whether there would be a different interpretation of the duty to consult from an Indigenous legal point of view.
I definitely know that when consultation processes began, a lot of First Nations actually invested, sometimes provincial funding regimes invested into First Nations consultation protocols or consultation laws. There's quite a few of them out there. I work with a group that actually have a resource law. So that process to me is a really good start in creating a process that will actually get to consent for First Nations. But certainly it seems, and probably it's true for any government, any government doesn't want to give up jurisdiction, and they see that happening if they actually start following these processes that are developed and defined by Indigenous peoples. Certainly there's an active dialogue and discussion about co-decision making and about processes that try to incorporate Indigenous principles and Indigenous laws, and certainly a final decision that could be called consent by the First Nation governing authority. But none of those have found their way into court, so we don't know whether or not there's any there's any sort of boundary rules around whether or not our rules of engagement around how these processes should be engaged in by the provinces or could be better engaged by the provinces. But I think that day will come, and then we'll see how courts deal with it. And my big concern is that there's not enough Indigenous judges out there to actually understand why it's important for Indigenous peoples to use their own authority, jurisdiction, and law.
I would add that I think you will probably see this play out in modern treaties, probably in British Columbia, when in time, I hope, the BC treaty process reaches maturity and British Columbia is, the boundaries of British Columbia are fully covered by modern treaties. I think you will probably see within the terms of those modern treaties agreement and compromise between the Aboriginal peoples and the Crown about how consultation should work on matters governed by the treaty. And so you will likely see Aboriginal input in that area in future. But the BC treaty process is working with glacial majesty, and you're likely to see a lot of litigation before that time arises.
Well, on that note, I think we've come to the end of our time. I really would like to thank you both for being so frank and clear, frank personally about what you feel about think about the duty to consult, but specifically about the origin of the duty to consult as emanating from the honor of the Crown. And certainly I think what we've heard from you tonight is the Crown has a heck of a long way to go. And so anyway, that was, I think, very, very interesting from the point of view of seeing specific examples of places where the Crown, the government in particular, can do a whole heck of a lot more. But I'd also like to thank you for giving us a sense of hope around the perception of the duty to consult and treaty making as a peacemaking project, and helping us to see it more as a process that can be much, much more collaborative, and so giving us some hope going forward. So anyway, I'd like to thank you both very much for speaking to us, making this clear. Of course, there's no real clarity, as you pointed out, no three-step process as to what duty to consult is, which makes it difficult. But I think you've given us a really good sense of what it is and where we've got to go. So thank you very much. I'd also like to thank our Public Legal Education Coordinator, Sara Das, and our administrator, our interim administrator, Jose, for their organizational skills in getting this event together, pulling this event together. I'd like to thank our crew for their excellent technical expertise, and to all of you for attending. Thank you very much, and please do, if you have comments to make, fill out your evaluation forms. And I just, as a last thing, have a couple of little gifts for our guests. There's small things that Sara can travel back with. Thank you very much for attending.